What's up, everybody? And welcome in to another episode here of The Lawyer You Know. And today we're going to talk about Kouri Richins' bond hearing. We're going to hear from a forensic expert as to some of the evidence they have against her. A detective also testified to kind of a lot of the evidence we've already discussed in the probable cause affidavit. But then we also get to hear from the judge what he thinks about this evidence, what he thinks about motive, and what he thinks about her potential danger to the community and whether or not she will have a bond or bail set for her potential release pending trial. Hit that like button if you are interested in this content, the Kouri Richins case, and subscribe to our page if you haven't already. I want to jump right into it and get through as much of this testimony and discussion from the judge as we can.
Not match the carrier records that we received from the phone company.
Did you analyze forensic extractions of an iPhone belonging to the defendant that was seized April 13th of 2022?
I did.
Does it contain digital information pertaining to the night of March 3rd and into the morning of March 4th, 2022?
It does.
What does that phone show? Well, let me ask it this way. What is the last time that phone is used on March 3rd of 2022?
The last activity reported on the defendant's phone is an activity device movement at 22:33 hours or 10:33 p.m. on March 3rd.
When was the next time that phone was used?
The phone was inactive and then ultimately unlocked at 3:07 a.m. on March 4th, 2022.
Was there anything that happened between those two timeframes?
On that device?
On that device?
No.
Does the extraction of that phone indicate if it was moved in that time frame?
It does.
And how are you able to tell that?
Through the download. In this case, we use Cellbrite for the download. In the download, it gives an activity, like a connected device activity movement. Usually that's an indicator of another connected device, such as a tablet or a smartwatch or something of that nature. Those two devices will communicate with each other and report potential movement of the phone through that application.
Was there anything significant that occurred at 3:22 hours on March 4th?
At 3:22, yes, a 911 call was made.
So between the time that the phone is used at 3:07 that morning and 3:22, is there any activity that could be seen from the download?
There is.
What is that?
At 3:07, the device is unlocked. At 3:08 a.m., the device reports some type of movement. Either the device itself or a connected device is moving. At 3:12, the phone was unlocked. At 3:16, the phone was unlocked again. At 3:19, the phone was unlocked again, potentially twice. There was movement again at 3:21, and then at 3:22, the 911 call was made.
So all this movement, phones locking, unlocking, all this stuff before the 911 call. And we remember she was apparently sleeping in the bedroom of one of their children who was not feeling well while all this was happening to her husband, and he was passing away due to allegedly her poisoning him.
So roughly a time frame of 15 minutes between the first time that phone is used and the time that a 911 call is placed.
Correct.
Now, the attached device that's recording movement, could that be an Apple Watch?
It could be.
Do you have any way of telling from the extraction you examined what that device was that was recording that movement?
So far in the extraction, I have not been able to. I may at some point, but at this point, no.
And as far as the movement, what kind of movement is this? Is it significant?
It is significant, I think, for occurring in a home.
And can you explain what that movement was?
Correct. So at 3:08, there's movement on the phone, or on a device is connected to that phone is moving, and it moves. I don't remember the exact amount of time, but I believe it's several feet. I do know that at some point there was two movements right before the 911 call, and they're both significant. One was about 240 feet, like 74 meters and change, and the other one was about 130 feet.
And we know all about step data from cell phones. We heard about it in Murdoch. We're going to hear about it in the YNW Melly case, and we are hearing about it now in Kouri Richins, and they can see how much movement was taking place, how she was walking potentially all over the place, but again, apparently didn't know what happened if we're sticking to her story, and she was just in bed with her other child, and immediately when she found her husband, she called 911. That's her story.
This is right before the 911 call.
Okay, thank you. As you were analyzing the forensic data from that extraction, were you able to observe any noticeable patterns of deletion from that phone?
It appears that there is some deletion in that device.
Okay. And can you describe what is being deleted in that phone?
It looks like there's gaps in things like web history, web searches, particularly the call up. When a person makes or receives a call or a text, Those are recorded in the call log of the phone.
And just a reminder, deleting stuff out of your phone doesn't actually make it go away. That can actually show that you were trying to delete stuff. Now, if it's that damning, maybe showing that you deleted something is better than what you actually deleted, but they get what we call a negative inference, and they can explain what you deleted and how that time corresponds with what you were probably doing at that time.
And there are there's messaging that is included in the carrier report, the call detail record, that I would expect to see also logged within the device that are not in the device.
Okay, so you're seeing those in the carrier records, but not on the device themselves.
Correct. For instance, there's multiple calls and texts to an individual. I would expect to also see that retained in the call log of the device itself. And in a lot of instances, particularly in the weeks prior to the death, there's a lot of that is missing.
And from the carrier records, are you able to tell who those calls were going to?
Yes.
Who was that?
There are several people. But as it relates to this case, one that stood out was a witness that has been mentioned as CL.
So some of the calls that were deleted was the person that has been referenced as CL, which I believe is the drug dealer. And that is one of the calls in this time period where she says she was asleep, but she was actually awake moving around before she calls 911, is one of the people that she called and then deleted that call.
In those carrier records, were there logs of calls made to CL in January of 2022?
I don't recall January.
Did you analyze?
Maybe that wasn't, maybe he was not saying in that time period, but just throughout time on her phone, the calls to CL. Maybe that's what that was.
Extraction of a second iPhone belonging to the defendant that was seized in May of 2023.
Yes.
When did activity begin on that phone?
The activity on that phone started shortly after her original phone was seized in April of 2022.
Were you able to observe internet searches on that phone?
Yes,
And did you create a PowerPoint of some of those searches?
I did.
And just for the court and counsel's reference, this is docket item 141. Were you able to tell when those searches were done?
Yes.
How did you do that?
There is a date and timestamp of the history, the web history. So for instance, if you visit a website and you click through it using your device, it will report what date and time that you did that connected to that website.
I see. On April 18th of 2022, did the phone access an internet site of an article entitled "What Happens to Deleted Messages"?
Yes.
That's never good, but a lot of people do search that, if I'm being fair. And that's a question I would ask if I was the defense attorney is, a lot of people search stuff like that, right? Doesn't mean they murdered anybody.
On May 10th of 2022, did that phone access a site for an article entitled "How Do Police and Forensic Analysts Recover Deleted Data from Phones"?
Yes.
Okay, that's getting a little worse. We're digging a little deeper. Not just what happens to deleted messages, what happens when law enforcement tries to extract them.
Did that phone was a query placed in that phone, quote, "Can cops, period, uncover deleted, period, messages, iPhone," close quote?
Yes.
Did that phone search, quote, "How to, period, permanently delete information from an iPhone remotely," close quote?
Yes.
Did that phone search, quote, "Luxury prisons for the rich in America"?
It did.
Did that phone search, quote, "If someone is poisoned"?
Luxury prisons for the rich in America. And then here we go. Now we're getting into poison.
What is it? Prisons for the rich in
By
America.
the way, this is the first time I'm hearing this and watching this with you guys. Some of you tagged me in stuff going on with her case. I'm actually about to do a live right after this, but I had a cancellation and appointment, so I figured I might as well watch this. And while I watch it, talk about it with you guys. So I don't know what's going to happen, but we're about to get some searches about poisoning, which again, not great.
America.
It did.
Did that phone search, quote, "If someone is poisoned, what does it go down on the death certificate as," close quote?
Yes.
Were you able to tell when those?
I mean, literally, this is incredibly damning search history, which is why I chose this witness to kind of listen to. Is people said, you have to listen to this. This is not good for Kouri Richins.
were searched?
The search themselves, there was no date and time reported for the individual search. However, I found corresponding websites to those searches that did have the dates and times in the web history.
And was there a certain time frame that these searches were made?
They were.
Can you describe what that was?
It's typically between, well, shortly after her original phone was seized. So from middle of April of 2022 through, memory serves me right, about August of 2022 off and on.
Now, you mentioned your training with cell phone mapping using cell tower data.
Yes.
Have you employed that in your review of the evidence in this case?
I have.
And specifically, can you explain just briefly how cell phone mapping is done using cell phone
Sure.
cell tower data?
Sure. Sorry, I looked that way. I'm used to talking to a jury. So cell mapping is accomplished by taking call detail records that contain tower location in them and putting them in map.
I'm going to
So it
skip
takes
the
this-
explanation about
And
how he does his expertise and all the science behind it and just kind of get to the facts.
are you able to tell any directionality from
sector.
how many sector can you tell that it's? Are you able to track that phone's movements on February
Here we
11th of 2022?
Yes,
At any time was it at or near a Maverick gas station in Draper, Utah?
it is.
And are you aware of the significance of that location in this investigation?
I am.
And what is that?
This is the location that CL had indicated to detectives that she bought drugs on behalf of the defendant.
So why is the mapping and where her cell phone was located at that date? Because it corresponds to her meeting with her drug dealer, and it corresponds with one of the attempts or right before the attempts to poison her husband.
Do you recall approximately what time of day that was? It was there.
She shows up on that tower near that Maverick at about 6:49 p.m. and remains there until about 8 p.m. on February 11th, 2022.
Does that phone make any calls or send any texts while at that location?
It did.
And to anyone notable to this investigation?
Yes, two people.
Who was that?
One would be to another acquaintance in which CL indicated she had purchased the drugs from, and CL was also texting with the defendant.
While she was at a gas station in Draper, purchased.
So CL confirmed that's where she was. She was getting the drugs to sell the defendant, and she was also texting, calling another acquaintance. And the reason this is all important is you would think if you have a witness, her testimony should be enough, especially if she's a witness for the prosecution. She's going to testify how the defendant got the drugs. But you have to remember, CL is a drug dealer and a former convicted criminal. And so she might not be that great on the stand, or he, I don't know if it's a she, might be that great on the stand. So the defense is going to be able to pick her apart potentially and pick apart her credibility potentially, which is fair game. So what do you do as the prosecution? You get other objective evidence like cell phone data that will corroborate what your drug dealing star witness is going to testify to show that she is in fact telling the truth. And why not? What does she have to gain from telling the truth? She may have gotten a deal of some sort, but she cannot fake or make things happen with cell phone records to make her at the locations she said she was at before those records even existed, or she knew those records existed.
Purchasing narcotics.
Correct.
On that day, did the phone go to a location? Did the phone go to a location in Heber City?
It did.
Was the mapping that you did of CL's phone consistent with the account that CL gave to law enforcement regarding that first drug purchase?
Yes.
Were you able to track CL's phone movements on March 9th of 2022?
Yes,
Was the phone ever in Francis, Utah on that day?
it was.
Was it ever at or near the same Maverick in Draper, Utah?
It was.
Were there any communications from the phone at that time while it was at the Maverick?
Yes, at the Maverick, yes.
Did it communicate with any phone belonging to a person relevant to this investigation?
It did.
Who was that?
At the Maverick, it communicated with, I guess, corroborating witnesses to the drug purchase on the 9th. When the device was utilizing a tower in Francis, it was about midday on March 9th, and CL's phone was in communication with the defendant's phone.
While she was in Francis, Utah.
Correct.
Did the phone go to a location in Midway, Utah on or about that day?
Yes,
Are the movements that you tracked for CL's cell phone on March 9th of 2022 consistent with the information she gave to law enforcement in this investigation?
yes.
Finally, I want to speak with you briefly about Mr. Eric Richins' phone. Did you analyze a forensic extraction of his phone?
I did.
When was the last use recorded from Eric's phone?
From memory, I believe it was about 9:58 p.m. on March 3rd, 2022.
And the times that are on the extraction from that are populated in the Celebrate download, are those, what time zone are those given in?
Typically, the extraction is provided in UTC 0. Yes.
And so do you have to, so can you just briefly explain what UTC 0 is?
All right, so UTC 0 is Greenwich Mean Time, but on the 21.
You know that.
The Mountain Standard Time, you would have to go back. I just have one moment.
Are essentially two explanations for why things might be missing. One in a download. One is that it's not captured in the download, correct?
Correct.
Okay, and that can happen.
It can.
I believe this is now cross-examination by Kouri Richins' attorney.
And then the other is whether or not it's been deleted.
Correct.
In this case, all you can say definitively is that it's missing, correct?
Correct.
And just in case you're wondering, the judge is the fact finder here. The judge is the decision maker. The judge is doing everything. All of this is for the judge. And it's not beyond a reasonable doubt. It's nothing like that. It's just basically probable cause. And then it's a balancing factors of whether or not she's a danger to the community, whether or not she's a flight risk. And we've gone through a lot of the elements to whether or not there's going to be a bail set and how high that bail should be set at. I'm sure we will hear that when the judge explains his reasoning and ruling, which again, I don't know what it is. I've just heard some little tidbits that this is what it's going to be about. So I'm really looking forward to hearing what the judge took from all of this and what he thinks about Kouri Richins at this point.
Now, with regard to movement, that could be any device that is essentially attached to the phone through an app, correct?
It could be, yes.
Okay. And so,
sorry, one of the other elements of this bail bond setting balancing is how strong the state's case is. So the likelihood of guilt. And that's why the state is putting on some evidence. That's why the defense is saying, well, it could be this, could be that. That's not that strong of evidence. It's not a slam dunk. It doesn't mean that for sure. It could mean this or that. That's kind of why this back and forth is going on with this expert witness. It's also different rules than trial. He can testify to certain hearsay. He can, take certain leaps, and they can ask some leading questions that they might not have been able to ask at trial.
you can't say, looking at what you analyzed, exactly what device that was, correct?
So far, no.
Okay. And you can't tell where that device was in terms of location, correct?
Correct.
So it's possible that that could have been a device attached to it from some other location, but the phone's recording it, correct?
It would be unlikely.
But it's possible if it's connected to an app.
It depends on the range.
Okay.
So it would be impossible outside a certain range.
It's a good expert, I think.
And there's a number of different ways to, or different programs, and forgive me, I am not an expert in this. So there's a number of different programs or extractions that can be done on phones, correct? Different ways to do them.
Correct.
Okay. Did you perform an independent extraction on this phone?
I did not.
Okay, or on any of the phones you've talked about today?
No.
Did you analyze any data prior to January of 2022 on either CL's phone or either phone, or I guess the first phone belonging to Ms. Richins?
I don't believe I did.
Okay. Were you asked to only look at a particular date range?
Not necessarily, no.
Okay. Were you given the date range of interest?
Yeah.
Okay. And so you didn't cross-reference any communication or the frequency of communication between CL and Kouri prior to January of 2022, correct?
Correct.
So it could be that they communicated all the time and you wouldn't have known.
Yes.
So this could have been just a normal course of communication between the two.
Sure. Yes.
So you're saying you only did a certain date range. And in that date range, it seemed like this, but they could have just been friends. My guess is the defense can order those records, but so can the state to see if that is true. I'd be interested in seeing it.
Were you made aware of when the search warrant was, or when the first phone was seized?
Yes.
Okay. And were you given a copy of the search warrant?
No.
Okay. Were you made aware that the search warrant included evidence of homicide that they were looking at?
No.
Okay. And in that first phone, prior to Eric passing away, were you able to review any search history of the web browser
Whose device?
on the first device of Ms. Richins?
Ms. Reed, yes. Yes.
Okay. And were there any searches related to fentanyl on that?
Not that I found. There were not many searches available to
And
look at.
no searches related to prisons either?
No, not in that time frame.
No searches related to deleting messages?
No.
And so all the searches came from the second phone, correct?
The web searches mentioned, yes.
Okay.
Yes.
And that was the phone that was seized after the search warrant was issued for the first phone, correct?
That was, yes.
That's the phone
So
you got as a replacement, right?
Yes, correct.
I just want to return to this mapping, or move to this mapping that you discussed. Did you look at the mapping on the second phone of Ms. Richins?
I did not.
So the state didn't ask you to compare Ms. Richins' phone to CL's location at any point, correct?
They did.
Okay.
Yes. they
But you
did.
couldn't do it? Or didn't do it?
The records, the mapping location for those call detail records through Verizon are no longer available
On the second phone?
on either phone.
Okay. So you were able to get them off of CL's phone, but because of Verizon, you weren't able to get them on Ms. Richins' phone?
It's interesting.
And on that March 9th date, you discussed her being in Francis midday in the Maverick. What time was she at that Maverick?
It was about 3 p.m.
So after
2 or
she'd
3
been,
p.m.
after she'd been to,
She was
To Francis.
she was in Francis around midday.
Okay.
And she was at the Maverick at about 2:33 p.m.
okay. Did she go back to Francis?
She went to Heber.
All right. So that's basically the gist of what we want to get to with that cell phone expert. And again, I think this hearing was a little over 2 hours long. So that was just about 30 minutes of it. There was testimony from the detective that reiterated a lot of what we already saw in the arrest warrant that had all of that information in it. But I really wanted to hear from the judge, because when you can hear what the judge thinks about a case, and it's about, 15 minutes here of what the judge thinks, and then his decision on what the bail is going to be and how he feels about the evidence they have in this case against Kouri Richins. Let's take a listen.
The issue before the court is whether defendant Kouri Richins should continue to be held without bail during the pretrial period. Defendant is charged, among other crimes, with aggravated murder under Utah Code 76-5202 sub 2. To convict defendant of this charge, the state must prove beyond a reasonable doubt at trial that defendant intentionally or knowingly caused the death of another individual under any one of the following circumstances: for pecuniary gain, or by means of the administration of a poison, or of any lethal substance. Under Article 1, Section 8 of the Utah Constitution, a defendant charged with a capital offense has no right to bail if there is substantial evidence to support the capital charge. And under Utah Code 7720-201 sub 3, a charge of aggravated murder is considered a capital felony for the purposes of determining bail during the period before the state makes an election whether to file a notice of intent to seek the death penalty. Accordingly,
So Utah takes it even a step further. Like, the severity of the crime obviously matters, but basically it's you're presumed to not have bail if you're charged with an aggravated murder, which she is, for pecuniary gain, he mentioned, and then also by way of poison.
at this time, the aggravated murder charge in this case is considered a capital felony. Moving to the substantial evidence inquiry, having considered the evidence offered by the parties, both through live testimony today and by documents attached to their briefs, which the
So again, they can call witnesses or they can just attach documents in this situation, because it is different from a trial and it's the judge making the decision. So he's mentioned severity of the crime, and then now the proof that they have. How good is it? Doesn't need to be beyond a reasonable doubt, but he's going to go through what evidence they have actually proving this crime when determining whether she should still be held without bail.
court has reviewed at length. And having had the opportunity to weigh the credibility of that evidence, the court determines the state's evidence, notwithstanding contradiction by defendant's evidence or arguments, could support a reasonable jury reaching a guilty verdict on the charge of aggravated murder.
Okay, and his language is very important. Words are very important. The state's evidence, even with the arguments made and the contradictions pointed out by defense, the state's evidence could lead to a reasonable juror finding a verdict of guilty for this aggravated murder charge. Could support a reasonable jury finding guilty. Doesn't mean they will, doesn't mean it's guaranteed, doesn't mean they proved it beyond a reasonable doubt. Could support that verdict by a reasonable jury.
Indeed, a jury could reasonably choose to rely on the state's evidence regarding means and motive and consciousness of guilt, which includes evidence showing that Eric Richins died of fentanyl ingestion, that he was not known to be a user of illicit drugs other than the occasional THC gummy, that defendant purchased 15 to 30 fentanyl pills from CL approximately 1 month prior to Eric Richins' death. Cell phone mapping confirms, or at least indicates to a reasonable jury, that CL's phone was near the Maverick and Draper on February 11th, and that while there, CL's phone made calls to acquaintances, capital A acquaintances as listed in the testimony and the information, and sent texts to defendant Kouri Richins, and that CL's phone then traveled to Francis and then returned, or was in Francis and then returned to Heber. We have CL's sworn testimony that she handed the fentanyl that she acquired to Kouri Richins in a hand-to-hand transaction in her driveway.
And that's why CL is going to be such a huge witness in this case, because she literally testifies, I gave her the fentanyl in her driveway. And then we know Eric Richins died from ingesting fentanyl. Now, how it got there is still to be proven by the state, but you can use this circumstantial evidence to make certain inferences and connect the dots. So that's why her testimony is so important. And then if the defense is just going to say, oh, she's lying, she's a drug dealer, she's a criminal, well, that's why the mapping and the objective evidence is so important to corroborate her testimony.
We also have motive.
All right, here we go. This is a big part. The judge talking about motive, because as we've talked about a million times, and again is coming out in the YNW Melly case. You do not need to prove motive. But the judge in this case has found there is evidence of a motive. Let's listen to what that is.
At the time of Eric's death, defendant knew how the premarital agreement would operate, but was not aware that Eric had changed his estate plan. So at the time of Eric's death, defendant's subjective understanding was that she would get a greater share of the marital estate if Eric died during the marriage, as opposed to what she would receive under the premarital agreement if the parties divorced. Moreover, evidence admitted in the case shows that in the months leading to Eric's death, defendant's personal and business accounts were overdrawn. She was making significant recurring debt payments, many of which were to hard money lenders, and that her lines of credit or lines of credit available to her were maxed out. And at the time.
So what's the motive? Money. We did a whole video talking about the money motive of Kouri Richins. Well, the judge agrees, and the judge is buying that motive.
Time of his death, Eric's life was insured for approximately $1.2 million, not including the policy related to the buy-sell agreement, with defendant listed as the beneficiary. Moreover, we have evidence from which a jury could reasonably infer consciousness of guilt. We have evidence regarding the search history that was extracted from defendant's second phone after her first phone was seized. And then we have inconsistent statements made by defendant as compared to other evidence in the case regarding whether she called 911 immediately, whether she performed CPR, whether she did something else for the 50.
So that's why the forensic expert was so important, and why, the 2-phone conversation was kind of confusing, but important. And it's not necessarily that she was making those searches before she was deleting messages or making those searches to try to cover anything up, but she had already tried to cover up, and it sounded like she was trying to figure out, will they still find them? Am I still in trouble because I know what I did was wrong, aka consciousness of guilt.
15 minutes between discovering Eric dead and calling 911. In considering this evidence, a jury could reasonably choose to discount and find unpersuasive defendant's efforts to poke holes in the state's case. And in so doing, a reasonable jury could reach a verdict of guilty beyond a reasonable doubt on the charge of aggravated murder based on the state's evidence.
And again, it's could. They could, not that they will or should.
For these reasons, the court determines there is substantial evidence to support the capital felony charge of aggravated murder against the defendant in this case. Having made that determination, the court considers whether it has discretion to grant defendant bail, notwithstanding that she has no right to bail under Article 1, Section 8 of the Utah Constitution. And having considered the arguments and authorities cited in the parties' briefing, the court determines as a matter of law that in the case of a capital felony that is supported by substantial evidence, while the defendant does not have a right to bail, the defendant may nonetheless still request bail, and the district court has discretion to grant bail if the circumstances warrant doing so.
So he doesn't have to. It's not a must. It's not a shall. It's a may. He has discretion to grant her bail, even under these circumstances where Utah makes it clear that you do not have to give a person bail in this situation.
But the circumstances of this case weigh soundly against granting pretrial release of any kind. First,
but the circumstances of this case weigh heavily against pretrial release of any kind, aka she is not getting bail. She will remain in prison waiting for her trial. This is always a huge kick to the stomach for any defendant, although it should not be a surprise in her case. And let's listen to the reasoning the judge gives.
Defendant is charged against granting pretrial release of any kind. First, defendant is charged with aggravated murder, which carries the possibility of sentences as severe as the death penalty and no less severe than an indeterminate prison term of 25 years to life. The severity of those sanctions, the severity of the sanctions that follow a conviction for aggravated murder creates a powerful incentive for a defendant to resort to desperate acts that might include harming themselves, harming the members of their family, or harming witnesses in the case. Because an incentive this powerful cannot be adequately managed in the community, it weighs heavily against granting any form of pretrial release.
So what he's saying is, because there's so much evidence, because the crime is so severe, because the sentence is so long, 25 to life, then even level-headed, good people might resort to horrible, unthinkable things like hurting family members, hurting themselves, hurting witnesses, trying to flee, destroying evidence, whatever it may be. And the community just might not be safe if there's a bunch of people looking at life in prison out running around trying to do anything they can to not end up in prison for the rest of their life.
Second, the state has offered substantial evidence the defendant procured fentanyl on more than one occasion, and on at least one occasion deployed that fentanyl to cause the death of another person. As a general matter, An individual who is capable of this kind of decision-making is not a good candidate for supervision in the community. More specifically, given the uniquely dangerous nature of fentanyl, which has been demonstrated tragically by events in Summit County, defendant's alleged conduct, as supported by substantial evidence, is especially dangerous. Indeed, these circumstances constitute clear and convincing evidence that defendant would pose a substantial danger to the community if released on bail, a substantial danger that cannot be adequately managed by any combination of conditions of pretrial release that are available in Summit County. For these reasons, the court finds the circumstances of this case, as supported by substantial evidence, weigh soundly against any form of pretrial release. The state's motion for pretrial detention is granted. Defendant Kouri Richins shall continue to be detained without bail during the time she awaits trial or other resolution of the criminal charges against her. Ms. Richins, you have the right to an expedited appeal of the court's ruling today. You must file a notice of appeal within 30 days of the court's ruling, and you have the right to be represented by counsel on that appeal.
Yeah, and so she can appeal if she wants to, but all the presumptions are against her. Really, the only way to get it is judicial discretion, and that's the hardest thing to overturn on appeal. Like I said, if the statute or the rule says you have to do this, judge, and the judge doesn't do it, you've got a good shot at appeal. If the case law or the rule says, judge, you weigh it and you make your call, it's very hard to overturn that, which is what has happened to her. So basically, danger to the community or herself, serious offense, long sentence, and enough evidence that a reasonable jury could find her guilty of this heinous crime. So that is the bond hearing. The defense filed basically a motion for reconsideration. It sounds like she was held without bond and they thought that she should get one. The state put on evidence showing that she should be detained pre-trial, and that motion was granted. So that is where Kouri Richins will stay. If you guys are interested in this, I will keep taking a look at it and keep breaking it down and answering your questions on it. Let me know what your questions are in the comments, and please hit that like button on the way out so that I know this is content you are still interested in. But for now, that's all I've got. I hope to see all of you in the live in a few minutes, which this is going to come out after. So it's just kind of like Inception. Until next time. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.